Good afternoon. We will resume the hearing. We have our fifth panel comprised of Mr. Samuel M. Syke, Jr., representing the Association of American Railroads, Mr. Richard E. Weicker, representing the BNSF Railway Company, and Ms. Louise A. Wren, representing the Union Pacific Railroad Company. Welcome, and please proceed.
Thank you, Chairman Nottingham. It's a pleasure to be here this afternoon on behalf of the Association of American Railroads. This is an important proceeding. We recognize how much effort has gone into it on the part of the board staff and the board members. These issues are not easy issues. The various parties to this proceeding have been dealing with them, and some might even say struggling with them for the better part of probably the last 15 years. AAR has participated in the earlier stages of this proceeding in the hearings back in 2003 and 2004, and among other positions, we advocated back then the development of appropriate standards for cases involving truly small shippers, because we believed at the time that a lot of the concern about the board's existing standards was whether they would accommodate the interests of truly small shippers. As we heard this morning, the focus has shifted from truly small shippers to small cases, and relief, they will bring truly small cases, and we support the board's proposal to have two simplified standards. The simplified SAC standards that would address the intermediate cases, and the three benchmark standards that would address the truly small cases. I'm going to direct most of my comments this afternoon to try to, at least, to the questions the board posed in its January 22nd decision. And I'm going to begin with the issue of eligibility, which for the railroads is clearly a critical issue in this case. And AAR approaches that critical issue really in terms of concept rather than numbers, hard numbers, because the individual member railroads have probably somewhat differing views about hard numbers. So I'm not going to be giving you numbers, but I am going to speak to the critical issue underlying the eligibility criteria, and that is how much traffic should be exposed to rate scrutiny under standards that are simplified and less than the optimal standards that the board has to determine rate reasonableness. That's really what's at stake for us. You have constrained market pricing standards that the board has repeatedly identified as the best and most reliable available to it, and everybody knows that stepping back to an alternative standard, particularly in this case the three benchmark standard, is a step away from the most accurate standard that you have. And the question is, the line you need to draw, in our view, is how much traffic should be exposed to scrutiny under standards that are less precise. The persistent revenue inadequacy of most of the Class I railroads and the pressing need for additional investment in rail capacity underscore the need for eligibility criteria that are no broader than absolutely necessary to permit rate cases where CMP is too costly. Shippers in this proceeding have signaled a desire for eligibility thresholds that expose as much traffic as possible to the three benchmark standard, which has no demonstrable connection to CMP. Nobody's tried to defend it on that basis. And we think that exposing the reach of an admittedly inferior standard is a short-sighted position for the shippers to be taking. And it's not in the long-term national interest of a sound rail system. The board's 1996 decision in this proceeding and its notice this year both indicated that the benchmark approach should be the method of last resort, and with good reason. A widespread departure from CMP would occur under expanded access to the three benchmark approach, and that could adversely affect the railroad industry's financial prospects and its incentives and ability to invest in needed capacity. Now, we heard this morning about concerns that the railroad's adverse revenue impact concerns were exaggerated. And the reality is, none of us sitting in this room knows how many cases will be brought under revised rules. We may have our guesses, but nobody knows for sure. However, the railroads have to be prudent in this proceeding. They have to guard against the potential downside. Having come so far and gotten to the verge, and in some instances perhaps beyond the verge of being revenue adequate, we can't afford to let that be dissipated by exposure to rate standards that are not consistent with the CMP approach. And that's really the basis of our position on eligibility. There was a reference this morning to the board's, I believe, Table 2, which indicated that approximately 17% of the revenue on traffic above 180% of variable cost would be exposed under the threshold, exposed to challenge under the threshold the board has initially proposed in this proceeding. And there was a statement that that table had been discredited. I don't think it's been discredited, not in our judgment, but I think it's up to the board and its staff to determine. 17% of the revenue, and I'm not suggesting we would stand to lose all of that, but it's a non-trivial amount of traffic, and it reflects the basis of our concerns about the eligibility criteria. Let me turn to the maximum value of the case proposal and the so-called small case model that was discussed in the January 22nd decision, which I believe is an outgrowth of a proposal that AAR made, and various member railroads endorsed the same approach. And our basic approach was a shipper who doesn't believe that he is likely to receive rate relief ranging all the way down to 180% of variable cost could, in effect, increase the amount of traffic that would be subject to challenge under the respective approaches by stipulating that he would not seek relief below a certain level. So that, to make the example concrete, if a shipper had a movement with an RVC ratio of 300%, and the shipper can tell what his RVC ratio is, he doesn't need waybill data to do that, and doesn't believe or even necessarily desire to achieve a rate at 180% of variable cost, he could, in effect, stipulate to a floor of 240% of variable cost, and in effect double the amount of traffic that would be eligible to consideration under whatever standard we were talking about. In my hypo, I guess it's the three benchmark standard. AAR is encouraged that the board and other parties appear receptive to a proposal concerning the maximum value of the case that's similar to this stipulated approach that we talked about in our earlier comments. And we believe that the board's proposed modification could make sense. However, I agree with some of the shipper witnesses this morning. We can only say for sure whether it makes sense if we know what eligibility criteria it's tied to. I mean, if we're going to allow shippers who have movements generating revenue of millions of dollars a year elect to proceed under the small benchmark approach on the theory that they're only going to go for a portion of the relief, I don't think that's going to work. I don't think that's what the board intended when it said the three benchmark standard was in effect a standard of last resort. So although we would be comfortable with this approach if it is linked to reasonable eligibility standards, we don't think it would be appropriate if the eligibility standards are raised anywhere near the levels that were being discussed by some of the shipper advocates this morning. Now, the board proposed in the January 22nd decision that a complainant would be free to change its mind about what type of case to bring until the filing of opening evidence. We're not comfortable with that. We think that that could result in wasted effort in these proceedings, and there's a much simpler and more straightforward way to deal with the situation where the shipper decides that he has proceeded under the wrong standard, and that is to let him dismiss his complaint without prejudice and refile it under a different standard. But there's no reason why defendants should have to contemplate the possibility of preparing for one kind of case and then shifting in midstream to defend a different kind of case. On aggregation, AAR believes that it would be inappropriate for the board to abandon its aggregation rules because they are a necessary tool for avoiding or policing abuse of the small rate case process. However, we do think the rules could be made more flexible by creating a rebuttable presumption in favor of aggregation. In other words, the burden would be on the shipper to show that aggregation is not appropriate in an individual case rather than on the railroad. And we think that makes sense because the shipper is the party bringing the case and deciding what movements to include in a rate reasonableness challenge, and should have thought through that issue before the complaint is filed. The AECC proposal to base eligibility on railroad as well as shipper costs is another question that was posed in the January 22nd decision. We think their suggestion that eligibility limits should somehow be tied to the costs of railroads as well as shippers is not consistent with the statute, which clearly contemplates balancing the value of a case from the shipper's perspective against the costs that the shipper would incur to pursue the case. The intent of the statute was to enable shippers to pursue cases, and the underlying logic is that developing an expensive, full, standalone cost presentation would not be worthwhile to the shipper if the expected gain or value from the case is less than the cost of pursuing the case. The cost of the railroad of defending the case is not relevant to the issue of value from the shipper's perspective. AECC's argument involves a theoretical economic proposition about what constitutes efficient use of resources, but it has nothing to do with the statute and doesn't provide a principled basis for doubling the eligibility thresholds. Simplified stack. The board asked whether the statute permits the possible use of two simplified rate standards, and I believe also whether simplified stack could permissibly be one of those standards given the language of the statute. We think the answer to both those questions is yes. The statute, as enacted, directed the board to complete a pending rulemaking by a certain time period and to develop a simplified procedure in that rulemaking. Nothing in the statutory scheme limits the board's ability to develop additional or alternative simplified standards down the road. In fact, you did complete the rulemaking back in 1996, and this is a further step forward. And the statute certainly doesn't direct you to adhere only to one simplified standard. I think in this connection it's worth noting that SAC itself, which is the standard referred to in the statute, is only one of several constraints that a shipper can pursue under constrained market pricing. So as a logical matter, there's no reason why there could not be multiple simplified constraints adopted by the board. We don't think there's any basis in the statute to assert that the simplified SAC approach must be the simplified approach that's adopted must be disconnected from CMP and SAC. On the contrary, Congress made clear when it called for the development of a simplified procedure that it did not intend to erode the constrained market pricing principles adopted by the ICC for full SAC presentations. The board itself has repeatedly stated that CMP remains the most accurate and preferred methodology for evaluating the reasonableness of rates, and to the extent that simplified SAC borrows from and incorporates the logic of SAC, it's clearly closer to CMP than the three benchmark approach. Now let me turn briefly to a couple of points about the three benchmark approach.
And just like if you could just wrap up in about a minute, it would be helpful just to stay on track.
Sure.
I hate to cut you off.
No, that's fine.
Go ahead and wrap up.
I'm untethered here in terms of a light telling me where I am.
I know. I'm sorry about the time. This is your just sort of 1 minute notice, and go ahead.
That's fine. I just want to make the point about access to waybill data. We feel strongly that the shipper's request to have pre-complaint access to waybill data is inappropriate. It's contrary to your precedent. It would have adverse policy implications in terms of potentially dampening interests in contracts down the road. In fact, we don't think you even need to get to that issue if you were to determine, as some railroads and perhaps other parties have indicated, that contract rates should not properly be included in comparison group traffic. And I will wrap up with that and turn it over to Mr. Weicker.
Mr. Weicker, welcome and proceed.
Thank you. Good afternoon. Thank you for the opportunity to address the board, Chairman Nottingham, Vice Chairman Buttrey, and Commissioner Mulvey. I'm Richard Weicker on behalf of BNSF. I will try to guide myself through the board's order to make sure we cover those points and be happy to address any questions. First, in general, we support the board's efforts to come up with small case standards that are expeditious and simpler. We think what they have on the table comes very close to doing that and is a feasible approach that should be moved forward. On the general issue raised in the January 22nd order of a sort of small claims complainant would choose proposal, we think that could be workable, makes sense. We don't oppose it. It would sort of take the edge off whatever Witness Sharp was talking about this morning in terms of who's choosing what. The complainant would have a control over remedy versus cost. It could make sense. In terms of starting and stopping, we probably would endorse something like the AAR described. It's always possible to start over again. We don't think that if the shipper changes his mind, we should be prejudiced in terms of the procedure and time frame, but he would control his destiny, and the complainant could decide where they were going. We don't oppose that. I think that general package is a good idea. On the eligibility or the general questions on aggregation, litigation costs, and so forth, first, as to the aggregation issue, we support the board's original aggregation type of safeguards. We don't think a so-called small case should be a Trojan horse or something else. That seemed like a workable way to do it. A very practical way to soften that edge that keeps it in the board's control is make it a presumption. Make it a presumption that you can make it easy to rebut if it's troubling, and still leave in place the idea that there should not be a reasonable aggregation and just anything goes in this. Litigation costs, which is sort of the bulwark, the logical connection with these categories, we think that has sense to it. It does relate to the access issue. That's supposed to be what these rules are about, to make access at different categories. And we think these rules and thresholds should not encourage litigation. They should relate to the complainant's access issues. I don't think risk factor has anything to do with this. This isn't supposed to be a gaming exercise or something that drives to a point of economic indifference. If there's a problem, the shipper should perceive they have a problem, and we should be looking at the shipper's alleged or perceived access issue, not some other construct. And it should be the complainant's costs that are relevant, not the railroads. I think it falls to BNSF to address the otter tail issue that was raised this morning and has been debated. I have tremendous respect for complainants' counsel in that case. They are experienced and fine counsel. I think in this case there's a great deal of hyperbole to suggest that that was a simple case. It didn't seem simple to us. We spent a lot more than the $3.5 million threshold on that case, but there's nothing typical about that case. Not only is it the new rules, and we'll come back to that because we think they should simplify SAC cases and make them less costly, but in Otter Tail, it would be fair to characterize that as 4 standalone cases. They started in June of '03 with the first filing of the standalone railroad, and recall that the choice of the standalone railroad and the initiative, and I'm sorry to digress into this, but it's been raised, there's a lot of talk. I'll make this as brief as I can, but it's very relevant if we're going to talk about the comparison to standalone costs. First, they filed the standalone railroad. Within a month or 2, they did an extensive errata, which was basically a whole new standalone road, or a reworked one. We, of course, have to reply to these or figure out how to adapt to them at great cost through outside consultants and fine lawyers. Then, January of '04, they filed another standalone railroad with a new operating plan based on a revised traffic group. And then in April of '04, give or take, they filed another standalone railroad based on the operating model they adopted after the repudiation of the so-called string model, which the board and staff will recall was another whole sideshow fight over what kind of model should drive all the operating revenue and expense assumptions in the standalone railroad. A lot of time, a lot of money, and a lot of efforts. They could have, if you take their $4.5 million figure, which they probably got a lot of good value from complainants, counsel, and lawyers in that case for that, they could have done one round for probably $1.5 million. But be that as it may, it's the shipper's cost of what they choose to do. From BNSF's standpoint, we have to vigorously defend these cases. In the particular circumstance of the last few years or the period of this case, we had the privilege to be before the board on multiple cases, and the honor of defending them. We have to look at the broad concepts, and when we're spending a lot of money in one case on string model development defense against some model or something, we're thinking of the big picture. We do think the new guidelines, we shall see, have simplifications in various operating assumptions, IRCS models, things that should bring the costs of these cases down. That remains to be seen, but there's nothing to keep the board from periodically revisiting what it establishes here, at least not that I'm aware of.